Welcome to the 92nd Street Wise State of Democracy Summit. I'm Farai Chideya, and we are going to be talking about the Supreme Court. No doubt, lots of great stuff to talk about there, and also an incredible group of people. I want to go through with some of these incredible guests the questions that they have actually presented to me. I'm going to let you in on a secret for good panels. I do something called leading questions, where I ask people to suggest a framing question for the topic. And because the Supreme Court is such a wide-ranging topic, I want to start with Emily Bazelon, staff writer at the New York Times Magazine and lecturer at Yale Law School, who suggested asking what happens when the Supreme Court lurches from the American public. And we certainly have seen a lot of divergence. How should we think about this, Emily?
Thanks so much, Farai. It's really a pleasure to be here with all of you at such a momentous and kind of teetering moment for the Supreme Court. You know, in the last few years, I think there have been some warnings that the Supreme Court is moving significantly to the right. And this term is going to offer a kind of real proof test of that in the areas of abortion and gun regulation and the ability of the federal government to do things like protect public health, for example, by the Biden administration's vaccine mandates. So the Supreme Court is just being very large in terms of its direct impact on American life. And at other moments in history, when the court has diverged sharply from public opinion, we have seen a kind of self-correction with some reining in or threatened reining in from Congress. And with public criticism. So I'm thinking of the 1860s, in which Congress changed the number of justices on the court 3 times. Then there's the famous episode during Franklin Roosevelt's administration, where we see the court refuse to uphold various pieces of New Deal legislation. FDR says he's going to change the number of justices, enlarge the court. And that doesn't happen, but a key justice changes a vote in another New Deal case, and then other justices retire. And FDR ends up with a lot of authority over the court. You could also argue that in the 1960s, the Warren Court moved to the left in a way that was out of step with public opinion, especially on in criminal procedure cases, and that President Nixon then ran in opposition to the court, and we saw the court perhaps self-correct in that domain as well over a longer period of time. So those are the historical moments I look back to. The big question for me is that these are not formal constraints on the court's power for the most part, at least except for the 1860s. They more have to do with public opinion and the idea the court has of itself as a legitimate institution and as part of democracy. I see a lot of lip service to that among the justices right now, everywhere on the spectrum of the court, from Justice Breyer, Justice Sotomayor, Justice Barrett, Chief Justice Roberts. But whether the court really plans to rein itself in, I think, is very much up for grabs. And to me, here really front and center is the fate of Roe versus Wade and abortion. And what I see likely among the justices, based on their past records and statements, is a willingness to really take a big bet and either overturn Roe directly or really change the idea that we have a constitutional right to access to abortion in this country. And I think that is going to be a real test for the American people. Polls on abortion have not changed a whole lot since Roe, but there is strong support for more access to abortion than I think the Supreme Court may continue to allow. So, that is a really tricky moment for American democracy. And to add one more thing, if we end up also with the court unwilling to let the federal government really act through its through administrative agencies, something that Kimberly has written about recently and that various conservative justices have expressed a lot of doubt about, that is an even more fundamental challenge to the way the branches interact with each other. And that seems to me like it would really cause just a potential huge crisis for the country.
Thanks, Emily. I'm going to move on to Kimberly, Professor Kimberly Whaley. She's a professor of law at the University of Baltimore School of Law and has a book coming out how to think like a lawyer and why. So you have presented us with a question. How do you expect this court to approach the Constitution and statutory law given the justices' professed adherence to so-called originalism and textualism? And so why don't you, I would ask that you define those terms a little bit. I've been trying to read up on this because it's so relevant.
Right. This is a moment in history, I think, where, wonky law professor speak is now jumping from the headline of everyday news. It's been for a few years now, not just because of this court, but because of the last presidency. But let me add, it's a real pleasure and honor to be on this panel. Thank you so much for the invitation. Perfect segue from Emily's comments. Few points just of basics. I mean, I think there's a crisis of civic education in this country. A lot of people can't name the three branches of government, let alone really explain what's in the Constitution. And by textualism and originalism, what I mean is sort of a conservative mantra, this suggestion, and I think we saw it with Amy Coney Barrett, Justice Amy Coney Barrett's confirmation testimony, that somehow good judges only apply the plain, obvious language of a text, that there's one way to read the Constitution, and good judges just read it. They're just translators of English, and bad judges read into it, what some people pejoratively call a living constitution. And if they went a little further, there's this concept of originalism, that if there's ambiguity, we need to get, in our DeLoreans like Michael J. Fox and Back to the Future and go back to the time of the framing and get in the heads of the men, the white males that drafted the original language and the culture at the time. And this has taken hold, frankly, in the public consciousness, this concept of just conservative reading of law, not just the Constitution, but statutes. But, it's a myth, really, because it's an old text. It's not very long. There's a lot of ambiguous language, and judges judge. They interpret things. And the question is, how do you read in that ambiguity? And this is what I think is a fundamental problem with where we are right now with this court, is on the one hand, that profess to be conservatives, and we call it a conservative court, under the auspices of narrowly reading the Constitution. Lots of times when I talk about abortion, which Emily just raised, people will say, yeah, well, it's built on sand, this concept of abortion. It's not in the Constitution. Well, friends, there's lots of stuff that's not in the Constitution, and the same concept of what we call substantive due process that gave rise to essentially the ability to stop government from deciding for yourself what to do with your medical care that happens to revolve around your uterus and having a fetus in your uterus. Lots of things that we assume government can't do, like tell us how to raise our children, tell us how to educate our children, tell us what jobs we can and cannot have. None of that's spelled out in the Constitution. So one of the big concerns I have with this court is we have this myth floating out that they're conservatives, and it's the progressives on the court that are out there by doing things like creating rights that don't exist in the Constitution. If we start unraveling things like abortion rights, it's not very far from unraveling other things that we hold dear that aren't expressed in the Constitution. If that's our theory, it's got to be black and white in the Constitution or there's no protection. And at the same time, we're seeing democracy dissolve at the legislative and executive branch level, primarily through voting. That is, we're seeing the ability of regular people to elect our own bosses, our own government, that be diluted across the board, primarily through changes at the state level to whether valid votes are counted, not even casting votes. So at the same time, we're seeing democracy structurally wither away, not just in this country, but globally. We're seeing a Supreme Court that is poised, we saw with Roe, to roll back constitutional rights on this myth that somehow judges don't judge. Now, I think, I'm at the point where I might be more comfortable calling this not so much conservative, but quasi-radical or radical court. And what turned me really was what happened with Texas abortion law. And that is because as of this moment, Roe versus Wade, up until and the following case, Planned Parenthood versus Casey, protect against government interference in abortion decisions up until viability, which is 24 weeks. Texas doesn't do that. It regulates it at 6 weeks. The court didn't step in and say, wait a minute, we need to at least protect the Constitution as we've interpreted it. That's called injunctive relief. They did it for Biden when it comes to things like what happens at the border. They forced him to go back to Donald Trump's, policy of sending Mexicans back to Mexico. They know how to use injunctive relief. They didn't do it to uphold the women's right to choose. To me, that's pretty radical. So I worry about what happens to other constitutional rights that Americans think as, part of our birthright that aren't expressed in the Constitution under the guise of conservative judging. The other piece Emily mentioned, which is, I did do a piece in The Atlantic about this, and this is something also kind of goes down to this question of what's in and outside of the Constitution. After, with the New Deal, lots of new federal agencies dotting Washington, D.C., FDR and Congress decided we need more regulation of the economy after the stock market crash and the Great Depression. So Congress started giving power to agencies to make laws. We call those regulations. There are a lot more regulations than there are actual acts of Congress. And in a way, a lot of the authorities and sort of lobbying is shifted to agencies because Congress has been so dysfunctional, isn't really doing much substantive legislation anymore. Well, with the vaccine cases and some of the other statements from these conservative justices, I think there is potentially energy on the court to hold unconstitutional the idea of Congress passing off legislative power to agencies, which would, if the court starts tinkering with that, we're going to see massive deregulation as a matter of the Constitution, not as a matter of policy. And the last piece I want to say, which I don't think, people really understand, is, it's really hard to change the Constitution for good reason. It requires, both houses of Congress by a supermajority and state legislatures by a supermajority to agree to change the language. That's super hard to do by definition, by design. But when the Supreme Court interprets the Constitution, unless there is an actual amendment or a new court majority, that is essentially an amendment. That's like a footnote to the Constitution. These folks are not on there by election. They are, the last 3 members were put on there without the filibuster. So there's no buy-in from the majority of Democratic voters in the country. And when they make changes, like saying, for example, Congress can't pass off power anymore, they're not accountable to the public. And I'd like to see more of these changes stay in the legislature. And I think this court is quite robust in what it's willing to do under the guise of constitutional interpretation. And as a last point, I'll say the other critical issue is voting. This court has not been very open-minded or amenable or protective of the right to vote, which is not expressed in the original Constitution. So even if we see changes through Congress, like the Freedom to Vote Act, to protect the right to vote, this court might unravel it. And this is what we saw even in 2013 with the Voting Rights Act, the critical provision, Section 5, that gives DOJ the authority to make sure that states don't get cute and make it hard to vote. Gutted that piece, and we still haven't seen that put back in the Constitution. So the overall takeaway is this Supreme Court has more power than I think it should under the Constitution. And just back to Marbury versus Madison, it's the court itself that gave itself the power to interpret the Constitution. And my view is people just need to be educated about this more than I think these myths again surrounding this conservative court lend themselves to.
Well, Kim, thanks so much. And it's a perfect handoff to Professor Lawrence Tribe, who, of course, has, just been teaching the Constitution for 50 years, is one of only 75 people throughout history to receive the title of university professor at Harvard, and served as a member of the President's Commission on the Supreme Court of the United States, very much getting to these structural questions that you just talked about. And you presented us with a question: why bother advocating structural changes like court expansion that have virtually no chance of being enacted? And I'm hoping you can talk a little bit more about the President's Commission in that context. Thank you.
Thank you. It's an honor to be here. I find myself agreeing entirely with everything that Kim said, but I think she, if anything, understated it. We have an extremely radical court, the most radical in American history. The court is not only far to the right of where most Americans are on most issues, but it is far to the right of anything in the history of this country. Now, if the only disagreement I had with the court were substantive. I think it's going in a terrible direction with respect to abortion. I agree with Kim that that is simply the first step. It's going to dismantle other rights not mentioned in the Constitution. If that was all, then I think as a member of the President's Commission, I would have said, well, we better hold our fire because when Trump is president again, and he might well be, though he is less likely to be elected, he's poised to have an effective coup this next time. And when we have the Senate in Republican hands, and when we have even more reactionary judges, because it doesn't look like Steve Breyer has the good sense to leave while he can be replaced by an appointment by President Biden, then things will be even worse. And then if we've established the precedent that it's okay to change the structure of the court because you don't agree with its decisions, I can imagine a Senate led by Mitch McConnell and an administration led either by Trump or by some other demagogue, some other despot, moving the court even further to the right, rather than making a course correction in the direction that I think is necessary. So I'm really quite alarmed. I'm alarmed despite the fact that I agree with Emily Bazelon that sometimes the court is engaged in self-correction. One of the reasons that I was one of the members of the commission pushing us toward reforms as radical as enlarging the court or otherwise changing its structure isn't that I thought we have much chance of having that happen, but because I wanted to send a major signal that at least some scholars who are themselves rather moderate, I'm not exactly a flamethrower, I'm not far to the left, there are many people far to my left, but even some scholars who are sort of traditional Harvard law professor types, wonky types, think that the court has gone off the deep end and that it's really important to send that signal rather than sending the signal that people like Justice Breyer are trying to send on their book tours when they're selling their book, saying, not to worry, all is well. We are not just politicians in robes. We're all judges. We're all wonks. We're all following the original meaning or the plain meaning of the text. Not true, folks. The court is, in fact, powerfully ideological. It always has been. It's a question of what the ideology is. You can package almost anything in terms of original history or in terms of language. But what is clear is that this court has not only veered far from where most Americans are on most substantive issues, it is entrenching itself. It's doing that by upholding measures that suppress voting rights, by refusing to do anything about partisan gerrymandering, by striking down those statutes passed by Congress that protect the vote. Kimberly mentioned, among other things, the Shelby County case, but there are others, like the Brnovich case, in which the court purported to be following rather than dismantling the Voting Rights Act, but at the same time was interpreting it in a way that deprived it of almost all power. So what we have really is a court that is not only moving right on substantive issues, but making it hard for a country that is to its left express its views through the franchise. That is normally, with a country that is so overwhelmingly to the left of the court, there would be a series of elections in which more Democrats would get elected, more state legislatures would lean to the left. There would be a pendulum course correction, but several of us on the commission, including former Judge Nancy Gertner and I, were so persuaded that that self-correction is not likely to occur this time, that the court is basically locking in a permanent government of a largely white minority in the face of demographic changes and ideological changes, that we are really headed toward a profound clash, not just a clash that leaves things up in the air, but one that locks in a permanent despotic rule. I'm led to think, and I don't like thinking this way, I'm led to think of The Handmaid's Tale. In a world in which many of us a growing majority, women, minorities, immigrants, Black people, brown people, young people, old people, people who are not part of the wealthy white elite that is backing someone like Donald Trump, which that majority is governed by a minority. I think of South Africa and apartheid. I'm not suggesting that we are moving toward an apartheid society, but I want to use dramatic terms, despite my Harvard professorial tendency to be moderate and to try to seem, to seem calm. I'm using those terms because, folks, the situation is dire. It is drastic. We are not just moving far to the right, but we are moving away from a meaningful, inclusive, pluralistic democracy. And I think that is a constitutional crisis that we're living through right now. And I think that if we just move deck chairs on the Titanic, we're going to sink.
Yeah, thank you so much, Larry. And, I want us to try to keep some of these responses to each other tight because we do have a limited amount of time. But I personally do agree that, not that it matters what I think is the moderator, but I will just interject that with family coming from Southern Africa, one of my earliest experiences when I was just 4 years old was passing through South Africa. My family was not treated particularly well for obvious reasons. And I do think that framing some of the questions around where we're headed as minority rule really is something we have to think about, because I don't see it as necessarily just left and right. I have relatives who are conservatives who are also essentially, what one might think of as Colin Powell Republicans who are cut out of some of the discourse, both in the courts and in the House and Senate chamber. Emily, you wrote in 2018, when the Supreme Court lurches right, a big piece for the New York Times. Does it surprise you how fast things have evolved since you wrote just a few years ago?
Yes, in that I didn't foresee the appointment of a sixth deeply conservative justice in Amy Coney Barrett. And I think that's really shifted the composition of the court in ways that just underpin the concerns that Kimberly and Larry are raising, right? Because Chief Justice Roberts, as the chief of the court, the person whose name is on it, he's the person who has the most stake in the court's legitimacy. And he seems very aware that the court's public approval rating has plummeted to its lowest point since 2020. However, he is now a kind of sixth extra vote for a lot of the causes that are dear to the hearts of the rest of the conservative wing of the court. And so that has really, I think, shifted the dynamic on the court in ways that underscore the urgency of what Larry and Kimberly are saying. I mean, just to underscore what you're saying, I think Farai is one thing we're talking about here is being a small d Democrat, wanting majority rule. We do not have a kind of simple system of majority rule in the United States. The composition of the Senate, for example, which is very much written into the Constitution, pushes us away from that principle, but our checks and balances have been meant to basically preserve it. And I think one thing I'm hearing from Larry and Kimberly is a concern that the court is using its power to go further away from majority rule, to entrench its own power as the judicially supreme branch that gets to interpret the Constitution, and also to make it harder for people to push back by electing representatives to Congress or a president who disagree. And that's the dynamic that I think is, they're each pointing out is the most profoundly troubling, because it suggests a country that can't kind of rein the Supreme Court in or change the dynamics that we're talking about, or at least it has to overcome these really formidable barriers that the court is helping to put into the way.
Yeah. And Kim, maybe you can pick up a little bit on this from the perspective of how you see something that Larry mentioned was that there is no imminent retirement during a Democratic presidency. I mean, how do you think about the ways that different presidents and different justices have strategized about the cycle of being appointed for life. Some people have stepped down, others have chosen to serve until death. Some people have talked about term limits, for example. How do you think about these questions of longevity, duration, and choice?
Well, I'd be really interested in hearing more from Larry about what the commission talked about. I mean, I put some of the fault of this, frankly, at the feet of the Democrats as well as the Republicans that are clearly moving towards some kind of anti-democratic authoritarian rule from top to bottom and have been doing systematically for decades, right? And I say this because the filibuster is a really important thing. We're talking about it again. Will Joe Manchin and Kristen Sinema get around it for purposes of passing voting rights legislation under the guise of the big lie, right? They're still not willing to fix the alleged holes. The Republicans aren't willing to fix the fraud. They won't do anything. So it's very cynical. But remember, when Barack Obama nominated now Attorney General Merrick Garland and Mitch McConnell sort of took his own power that's not in the Constitution as Senate Majority Leader to deny a president his appointment power. That's expressed. Back to this textualism thing, right? Barack Obama didn't really say anything. He didn't even make a speech. He didn't peep back, right? And my understanding is from people inside the White House then, just as hearsay, what they thought Hillary Clinton would be, and it would all correct itself. Likewise, when it came to the 2 impeachment trials for Donald Trump, there is subpoena power. There is an authority to hold members in contempt through the sergeant at arms. They could have moved the Chief Justice, the Democrats, in the first impeachment for move them to call a witness, right? He's a judge. It was a trial. There's no limitations in the Constitution on his role. That's just ceremonial. They could have said, Your Honor, we call John Bolton as a witness. We move you to enforce our subpoena. Didn't do it. Didn't push Justice Roberts. And now we're here where, I mean, we're hearing a lot of discussion around Build Back Better. I think that's really important. But meanwhile, the clock is ticking on democracy. I agree with Larry. And it's not the next presidential election. It's November of 2022. It's less than a year away. It's the midterms. If the midterms go to Republican control, the House hands Congress to Republican control, we will probably see the end of the January 6th Commission. We will not see vital reforms to the Electoral Count Act, which would avoid basically a power grab on January 6, 2025. And I agree with Larry, what will happen is a successful coup, maybe a nonviolent one, but a successful one. So, Mitch McConnell's, in the Federalist Society's multi-decade through campaign finance reform and, killing that, other mechanisms of killing democracy and getting his Supreme Court conservative majority has managed to entrench minority rule. And it's not just at the Supreme Court level. It's in the lower federal judiciary now. And all we have to do is look at the vaccine mandates. Fifth Circuit, 2 Supreme Trump nominees basically saying Congress doesn't even have the power to give OSHA the power to mandate vaccines. Very radical. Sixth Circuit, more old school judges saying, you know what, actually, this is constitutional. It's within the scope of the statute. We're out. We don't have the power here. So I would frankly like to see, and I know I've heard, Joe Biden and others, the president mention recently how vital democracy and voting is. Of course, there was that international summit, but this is the stormtroopers are at the back door, and if they breach, it's very hard to go the other direction. So I would like to see, frankly, I don't know what to do about the court per se. It might be a little late. Maybe pressure on Justice Breyer. That's not going to create a situation where we have consensus again, or having to sort of agree, as Emily suggests. Justice Roberts is no longer in the middle like Justice Kennedy, where you had to kind of make a deal with him to get more moderate. Not sure what to do about the Supreme Court. Would frankly agree we need to have some structural changes, but Congress needs to get its act together and start passing legislation in the few months that are left where it has the power to maybe put some systematic structural things in place.
And Larry, I'm going to ask you to land the plane here. We don't have a lot of time yet, but I'm wondering who you consider the kind of superheroes here. You yourself use legal scholarship, teaching legal scholarship, writing public, pieces, serving on commissions. All these are tools that you use. what is the supergroup or the constellation of people and civil society entities that needs to engage in order to have a healthy Supreme Court?
Well, I think citizen activism is the name of the game. I mean, I do have a number of heroes among my own former students. The leaders of the two impeachment trials in the Senate were students of mine, Jamie Raskin and Adam Schiff. I used to have an enormous amount of respect for Merrick Garland, another former student of mine. I still respect him, but I wish he were not taking so long to investigate the conspiracy to overtake the government by a bloodless coup. That is, he's going after the foot soldiers and working his way up, he says, perhaps to people at the top of the violent insurrection of the 6th of January. But that was just plan B. Plan A, had it succeeded, and it came dangerously close, would have not required anybody to storm the Capitol. And there's no excuse for the waiting that Merrick Garland is doing before apparently investigating Trump and the people immediately around him. And that's one of the few things we really can do. It's not a heroic measure. It's just doing what a good prosecutor would do. And that is not always going from the bottom up, but when there is a top-down conspiracy, going directly after the conspirators, holding people accountable. They ought to be held accountable. And if the country is to have any hope of surviving this terrible period that we're living through, accountability is absolutely central. Because if we allow the people at the top to get away with murder and essentially destroying the democracy, then we can't hold on to it at all. It seems to me, I do disagree to some slight extent with Kimberly. When you get right inside the process, all kinds of things that sound good, like let's move the Chief Justice to call John Bolton as a witness. Well, Kimberly, if you're wrong if you don't think that they were thinking about that. They felt it out. The Chief Justice would have refused. And if the Chief Justice hadn't, the ultimate power lay with the Senate. And they would have overruled any decision on his part to take the more radical steps that we might want. So the idea that there are, there's fault to be laid on all sides, that's true in a way. And it would be great if the Democrats could just forget that Sinema and Manchin are unmovable, but those are simply facts. They are realities. And yes, it would be great if Congress got its act together, but suppose Congress did pass a dramatic overhaul of the voting rights system. As Kimberly pointed out, the odds are that this Supreme Court would strike it down. Suppose Congress gets its act together and passes a legislative codification of Roe v. Wade, saying that we have the power under the Commerce Clause to force abortion to be legal throughout the country, just as the Supreme Court earlier said that we could pass a nationwide ban on so-called partial birth abortion. You know what this court is going to do with that? They're going to say, oh no, the Commerce Clause doesn't reach that far. So, I find myself between a rock and a hard place. On the one hand, I want to be realistic about what's doable. On the other hand, I insist on idealism so that we don't basically paralyze ourselves by thinking that it's all over and that there's nothing we can do. And that's why I resort to notions like citizen activism. Major changes in this country's history have always come over the long run from the ground up. The civil rights movement was from the ground up. It was only after that movement really went quite far that the Supreme Court did Brown v. Board of Education. The women's movement was from the ground up. Women marched, women sacrificed in order to get the vote. Roe v. Wade was just the culmination of a long popular movement. And I think that's what we need now. My hope is with the future, with the next generation, with people who really have a long time ahead when they can reclaim a meaningful democracy.
Well, Professor Tribe, that is a perfect place to leave it. And we had a lot more we could have talked about, but not a lot of time. So maybe we need a part 2 at some point. I want to thank you so much. Again, we have been hearing from Professor Lawrence Tribe, who is a university professor at Harvard, longtime legal scholar, constitutional law scholar, and also was a member of the President's Commission on the Supreme Court of the United States. Emily Bazelon, who is a staff writer for the New York Times and also a lecturer at Yale Law School. And finally, Professor Kimberly Whaley, who is at the University of Baltimore School of Law and has a book coming out, How to Think Like a Lawyer and Why. Thank you all for joining us.
Thank you.
Thanks, Farai.